Colleagues, and welcome to Referendum-Bill-Committee, our 8th meeting for 2013. Apologies have been received from Annabel Goldie, and we have John Lamont here today to represent the Conservative Party in our proceedings. Agenda item number 1 is to seek the committee's guidance on a couple of issues. The first decision concerns item 3 in today's agenda, a discussion on the oral evidence of the referendum bill. And since that will involve discussing names of prospective witness, it might be more appropriate to take that in private. The committee agreed with that. And the second decision concerns the committee's next meeting after the recess. The main item is the review of all the evidence of the franchise bill. And obviously the aims to give the clerks as good a steer as we can at that stage of how that report might look. And I just wonder if it's appropriate we also take that proceedings in private also. Committee agreed. Thank you very much. That takes us to the second item on the agenda today, and a very warm welcome to Nicola-Sturgeon, the Deputy First Minister, and Government Strategy and Constitution also under her remit, supported by 3 government officials: Steve Sadler, who we've already met with Steve already on a previous occasion, who's the head of elections team, Helen Clifford, who's the bill team leader, and Colin Brown, who's the Scottish Government Legal Directorate. Before we get into the actual proceedings, can I remind members that the deadline for written evidence has now been passed. All submissions that have been received so far have been circulated, including some stuff that's been put in front of you today. Both the Subordinate Legislation Committee and the Finance Committee have undertaken a scrutiny of the bill and produced their own results, which has been circulated to us. And this is obviously a chance for the Deputy First Minister to respond not only to members' questions, but any issues that might have been raised in evidence prior to today's proceedings. So, with that, I would invite the Deputy First Minister to make a short opening statement, and then we'll move on to taking questions. Thank you.
Thanks, Convener. In October last year, we announced our intention to bring forward legislation to ensure that all 16 and 17-year-olds resident in Scotland could register for and vote in the referendum. EROs told us that given the timing of the canvass to compile the register for the referendum, they would need to have the power to collect details of eligible young people by the summer of this year. Given that the main referendum bill won't complete its parliamentary passage until November, we need to introduce this bill to establish the franchise for the referendum. This bill sets out who will be entitled to vote in the referendum and in particular puts in place arrangements to enable all 16 and 17-year-olds to register to vote. The timetable that the committee has agreed and published will, subject of course to the agreement of Parliament, see the provisions in this bill in place by the summer. That will allow EROs to start compiling the register for the referendum, including all those who will be 16 and 17 by the date of the referendum in the autumn of this year. We've worked very closely with registration officers to ensure that the process for registering young voters is as straightforward and accessible as possible, and I'm very grateful to them for the help that they are giving us. A young voter registration form will be distributed to all households in Scotland at the same time as the standard canvass form, coordinating with the existing process in this way, rather than trying to run a separate registration process, will ensure that the whole process is as simple as possible for the voter, while keeping admin and cost to a minimum. The arrangements put in place by this bill and the main referendum bill on access to the register are intended to strike a balance between putting young voters on an equal footing with other voters, on the one hand, with the need to ensure that their data is treated sensitively and responsibly on the other hand. We followed the existing registration process as far as possible while making some necessary modifications, for example in restricting access to the full register. The measures we are proposing to address any child protection concerns have been welcomed by child protection groups. Young people obviously take on a range of important rights and responsibilities at 16, and we believe that they should have the opportunity to have their say on the future of the country that they're a part of. So it's right, in my view, that 16 and 17-year-olds should have the opportunity to vote in the referendum on whether Scotland should be an independent country. With the important exception of lowering the voting age, the franchise for the referendum will be the same as that for elections to the Scottish Parliament and local elections. Eligibility to vote in the referendum will, following the precedent of the 1997 referendum, be based on residency. The other thing I just want to briefly mention, Convener, is the interest that has been on the position of service personnel and some inaccurate reporting of the situation and some criticism of the fact that we've not made special arrangements to allow them to vote. I want to be very clear that there is no need to make special arrangements. The arrangements which are already in place to allow service personnel to vote in elections to this Parliament will be the same arrangements in place for the referendum. Service personnel who have lived in Scotland but are currently serving overseas or elsewhere in the UK will have the opportunity to register for and vote in the referendum, and EROs will be responsible for determining applications from service voters to register to vote, as they are for all voters. The position for convicted prisoners who are detained in custody has also provoked some recent comment. The Government doesn't believe that these prisoners should be able to vote in the referendum, and the bill makes provision to this effect. Convener, in conclusion, the bill gives us the opportunity to ensure that 16 and 17-year-olds are able to play their part in deciding the future of our country on the 18th of September next year. In developing these proposals for consideration by Parliament, we've sought to place young voters on an equal footing with other electors. We need to engage them in the democratic process and ensure that they have access to the same information before they cast their votes in the referendum. But we must also take sensible precautions to ensure that in giving young people the vote, we also provide them with proper and adequate protection. I hope the committee agrees that this bill strikes the right balance there, but I now look forward to answering questions on the matter.
Thank you very much, Deputy First Minister, for that opening statement. I know there's one issue in particular which has been exercising the committee, which I don't think you referred to in your opening statement. That's the issue of individual registration and where the UK are. I think Stuart McMillan wanted to raise that issue with you.
Thank you, Convener. Good morning, Deputy First Minister. Certainly, it's, as the Convener said, I mean, one of the issues that has been raised going through this process has been the issue of the individual registration and the legislation going through Westminster and the implications, or the potential implications, for Scotland in terms of the timing with the referendum. Can you provide the committee with some information in terms of well, an update in terms of any discussions and any potential agreements, if there have been any up to now, with the Cabinet Office at Westminster? I know that was something that in earlier correspondence from yourself to the committee, you did indicate also that there were discussions taking place with the Cabinet Office. So can you provide the committee with an update today regarding that position?
Yes, I can. As I've previously intimated to the committee, my officials have been in regular discussion with Cabinet Office officials about the interaction there is between the referendum and the UK Government's planned introduction of individual electoral registration. We've made it clear, and to be fair to the UK Government, they've also made it clear that we want to ensure that the timescales of the two processes are compatible and to minimise any adverse impact on the referendum, on electors, or indeed on electoral registration officers. The Cabinet Office confirmed on Tuesday, following our confirmation of the referendum date last week, that the transition to IER in Scotland will not start until after the referendum. It will begin on or around the 1st of October 2014 in order to avoid any unhelpful interaction with the referendum. So I think that's a helpful development, and I hope it gives the committee the assurance they're looking for.
So just to, that is very helpful. So just to clarify, there will be no implications, no adverse implications for the referendum going forward.
That is the case. Obviously, we will continue to discuss detailed implementation plans with the Cabinet Office. Scottish and UK Government officials met EROs on Tuesday to discuss this and to make sure that we are continuing to ensure that there is no unhelpful interaction. But that confirmation from the Cabinet Office that the process of individual electoral registration will not begin in Scotland until after the referendum, I think gives us very helpful assurance that that will be the case.
That's very helpful, thank you.
Can I just ask one supplementary to that? In terms of the mechanism that's going to be used in the UK, will that be a subordinate legislation or will they require primary legislation?
As I understand, I'm just checking with officials that it's subordinate legislation that will be used in the UK to bring this process into being. More
flexible way to be able to deal with it. Okay, that's helpful. Thank you. James, I was going to come to you on this issue to do with voter registration.
Okay, thank you, Convener, and good morning, Deputy First Minister. I have a couple of specific questions relating to voter registration. First of all, in relation to the autumn canvass, which you spoke about in your opening remarks, we've heard some evidence to the effect that there can be inconsistent start dates for the autumn canvass. Some start on the 1st of October, some start on the 1st of December. Obviously, in relation to getting the register updated and as accurate as possible, it would make good logical sense for local authorities to have a consistent start date and also a consistent early start date. So can I ask what procedures are in place in the legislation to ensure a consistent early start date?
When exactly that process is started is a decision for EROs to take. They haven't all yet decided exactly when that process will start, but it will be on or around the 1st of October in all parts of Scotland. We can certainly continue in our discussions with EROs to feed in the views of the committee, if that is the view of the committee, that they should be starting as early as possible and on as consistent a basis as possible. Clearly, it's in everybody's interest for the register that will be used in the referendum to be as up-to-date as possible. Of course, there is the rolling registration process as well as the annual canvass, which allows people to add their names to the register. And this will include young voters up to 11 days before poll. But we'll certainly feed the view of the committee, if it is the view of the committee, to EROs that certainty and clarity around the start date and consistency around the start date would be something you wanted to see.
That's not something that is going to be in the legislation. That's something that you would do as part of the guidelines.
It's something we would, this is, as far as possible, and this is a comment that I guess will apply to much of what we discussed this morning, as far as possible, we want the provisions we're putting in place here through this bill to mirror the normal process of voter registration. We're not trying to create a different parallel system. We're having to make specific changes to allow for the extension of the franchise to 16 and 17-year-olds with the separate form in order to take account of the particular issues around that. But as far as possible, we want the process to mirror the process that is already in place, and that would be the case around the start date of the canvass as well. So it's not specifically covered in the legislation in terms of a specific start date for the canvass.
You would accept that a consistent start date would be helpful to the process, and you wouldn't want a situation where you could have a variety of start dates covering a 2-month period?
I think, I think a consistent start date in general terms, I think both, yes, that would be something we would want to see, but also something that is likely to happen anyway. I'm not sure it makes a huge amount of difference whether or not every single part of the country starts absolutely on the 1st of October, as opposed to, a few days or even a few weeks on either side of that. But the general point about a generally consistent start date is important. And not just important for the referendum. I think, important that we have that kind of system in place generally in order that people are getting onto the register. But again, the point I made earlier on, the annual canvass, although very important and the central part of the annual voter registration process, is not the only way of people getting on the register, because we now and have had for some time the rolling registration process.
Yeah, I'll move on, but I do reiterate, certainly my view, the committee will come to a view that I think a consistent and as early a start date as possible is helpful to the process of having an accurate register.
You move on to a different area, James. Can I just pick up one supplementary if it's a different area on that issue?
It's different on voter registration.
Okay, on you go. I'll pick up at the end.
Right. Okay. Again, in terms of 16 and 17-year-olds, obviously we want to ensure that we get as many 16 and 17-year-olds registered as possible, and I wondered on your view on the point in the NUS submission about extending the powers of the Society of Local Authority Election Administrators and Lawyers to cover referendum and to give them greater power specifically in relation to registering 16 and 17-year-olds. I wonder if that's something that the government had given some consideration to.
We'll obviously give consideration to all of the evidence that's been given in this early part of the legislative process, as we would do with any bill. There's been a lot of helpful evidence given to the committee orally. There's been some helpful evidence in writing. So yes, the short answer is we will consider all of that, including the proposal from the NUS that you've spoken about. But you know, my strong view is the process and the arrangements we're putting in place through this bill are sufficient in order to ensure that the majority, as many as possible. I want to see all 16 and 17-year-olds who are eligible to vote to be on the register and able to take part. I think what we're putting in place through this bill is enabling that to happen, not least because it is dovetailing so closely with the normal annual canvass process. So I believe that what we're doing here is the right approach, but yes, we will consider any suggestions that have been made, and as the bill goes through its parliamentary process, there will be opportunities for the committee and individual members to suggest where they might think we can improve things further.
You've not ruled out extending the powers at this stage?
I've not ruled it out. I've not ruled it in. I'm saying we're not yet at the end of stage one. You know, we clearly go through a process, as we do with every bill, of looking at all of the evidence that's put forward and making a decision about whether we want to take any specific suggestions forward or not. So I'm not saying we're going to do that, but we are still in the process of giving due consideration. I think it's only fair that if people go to the time and effort of submitting evidence, and the government gives what they suggest due consideration. But you know, I'm putting before you a bill that I believe puts in place arrangements that will enable all 16 and 17-year-olds to register to vote and to take part in the referendum if they want to do that. And you know, I hope that all of them do. I mean, one of the early concerns that was expressed when we first said that we wanted 16 and 17-year-olds to vote was that we may have a process that didn't allow all 16 and 17-year-olds to vote, the Attainer proposal. We listened to those concerns and have come up with an alternative arrangement that does allow all 16 and 17-year-olds to be registered to vote, and I think that's the right way to proceed.
Sorry, Deputy First Minister, a very technical point, but it relates somewhat to what James Kelly was talking about in regard to the start of the canvass being about that October day. Section 13 of the bill actually prevents anyone being registered on the young persons register before the 1st of December. Now, I'm assuming that date of 1st of December was in the bill before we knew about what the final date of the referendum would be.
I'll let Steve answer that technical point.
That's correct, Convener. That was there before we knew the date of the referendum, and also before we'd had subsequent discussions with EROs where they said they were looking to start around the 1st of October. That would intend to amend that date.
That's very helpful, Steve. Okay. I think, Patricia, you wanted to raise issues about participation area, I think it was?
About young people,
about
more
young
generally.
People, yeah.
Thank you, Convener. Good morning, Deputy First Minister. One of the areas of particular interest to members of the Scottish Youth Parliament when they gave evidence to us was around the nature of the actual registration form. And they had a particular concern that by saying on the form something along the lines of, you know, you can register if you will be 16 at the time of the referendum, that it might be an easier way, well, it might be a clearer way and an easier way of encouraging as many young people as possible to be very clear about their opportunities and not to either find themselves disenfranchised accidentally or indeed to register and find that they actually were not eligible, to actually specify the dates that applied. So, for example, I think the dates we were looking at were something like the 1st of December 1997 and the 18th of September 1998. And if you were born between those two dates, you could therefore be confident that you could register and get your vote. And I wondered if that was something that the government had considered or would consider.
The form is being tested at the moment, and we will know the outcome of that testing process by the time we get to stage 2 of the bill. So if that is something that came through from the testing, that the form as laid out in Schedule 2 of the bill just now was not clear enough and was not avoiding the kind of confusion you're raising the potential of, then yes, we would consider making changes to amend it. So we will have the appropriate opportunity to do that once we've got the testing of the bill completed. The Scottish Youth Parliament will listen to everybody's evidence and consider everybody's evidence. Of course, the Scottish Youth Parliament, I think, are to be congratulated for the campaign they ran for votes for 16 and 17-year-olds.
and indeed I think the committee felt their evidence was particularly compelling when we heard from them. Section 9.3, to go to the other end of the issue really, Section 9.3 of the bill talks about the publication of the register being allowed in limited circumstances, but doesn't yet detail, or perhaps won't detail, the circumstances in which that will be the case, or indeed to whom that register might be disclosed. And I wondered if that was something that the Deputy First Minister might like to clarify.
Well, I mean, we're very clear, and again, if there is a need through amendments to the bill to make this clear, we will consider that. But I mean, again, this comes back to one of the central kind of balances we're having to strike in this bill between allowing 16 and 17-year-olds to vote, but making sure that we protect the data of 16 and 17-year-olds, and we're very clear that only electoral registration officers and their staff will be able to have access to the register of young voters. I mean, an individual can ask an ERO to see a particular entry, but the access to the register of young voters will be restricted to electoral registration officers. We'll probably come on to this, I won't go into it in great detail, but in terms of the merged list, there will be restrictions on access to that as well that would go beyond the normal restrictions to an electoral register. So that's very clearly our intention. And again, I'm happy to consider whether there is any minor amendments we need to make to the bill to make that absolutely clear.
Thank you.
Okay. Linda Fabiani.
Yeah, on the same issue, I've been quite consistent all the way through this process, Deputy First Minister, about child protection, and I've been very heartened to hear from people that they feel there's been really good dialogue with the government on this, and that fair solutions have been reached. We can always look to make that better, though, and we do have a letter from Donald Urquhart, the Scottish Child Protection Chairs Forum, who, like everyone else in the field, has welcomed the work that has been done, but does make a couple of additional points that he thinks are worth looking at. For example, additional guidance on the form clarifying the process for a young person to register using another contact address when they're living away from home was one of them. And the other one was a general clarity they feel is required about the processes to ensure local authorities, social workers and support staff to be informed about the child protection provisions and the implications and their role. And I was just really looking for assurance that the dialogue, which has been excellent, continues, and that concerns expressed by people like Mr Urquhart will in fact be taken on board.
I mean, I think I'm happy to give that assurance. I mean, the issues that have been raised here, I think, are very legitimate issues and quite helpful issues. They're more for guidance, I think, than for the legislation itself. But I'm very happy to give the committee an assurance that will reflect those points in our considerations as we're considering the guidance around these issues. I mean, I think it's in all of our interest to get as many 16 and 17-year-olds as possible registered to vote so they can exercise their democratic right. And there will be a lot of people who are quite important in making sure that young people understand that they are entitled to register and take up that opportunity.
Thank you very much.
Any other wider child protection issues?
No, really just, as I said, we heard from the Children's Commissioner convener and we heard from various other people, and there seems to be a general satisfaction that child protection issues in particular relating to those who register younger have been well looked at, have been well considered. So I think that should be in record, but also the commitment given by the Deputy First Minister that the dialogue continues.
I'm absolutely happy to give that commitment. I think just to kind of go back to Patricia Ferguson's point about section 9, subsection 3. Subsection 3 there is actually a kind of cross-reference to the main referendum bill, which will deal with the access to the register. But as you will now see, because the main referendum bill is published, we are very clear in terms of the restriction on access that there will be to the register of young voters.
First Minister, my points connected to the two previous questions. It relates to section 7.2c of the bill, which provides for the non-disclosure of a young person's address, but schedule 2 of the bill, which actually details the canvass form, does not specifically provide for the non-disclosure of the young person's address. And I just wondered if the intention was, in light of the discussion we've just had, to amend that form so that the non-disclosure is more clearly marked on the form.
I mean, as I just said, I think to Patricia Ferguson, the form has been tested at the moment, and I think it's important it goes through that process of testing. So, as was the case when the Electoral Commission did the testing of the question, etc., we will look very carefully at what comes back from that process, and we will have good time then to make any amendments we think are necessary to the form before we get to stage 2.
Right, let's just pick up on some of the issues, Deputy First Minister. I know that Annabel Ewing was particularly interested in issues to do with armed forces. Do you want to pick up your issue now?
Yeah, thanks, Convener. Good morning to the Deputy First Minister. In last week's meeting, the 21st of March, I did raise this issue with the Electoral Commission, and I did cite a statement from the Advocate General Lord Wallace of Tankerness made to during the Section 30 Order debate in the House of Lords on 16 January 2013, and perhaps just for use of reference, I could read it out again. So he said, and I quote, "Members of the armed forces will be able to vote in the referendum if they are on the register in Scotland, either as a result of an address in Scotland or a qualifying address showing a connection to Scotland, such as service accommodation in Scotland, an address in Scotland where they would be living if they were not in the services, or an address in Scotland where they have lived in the past." And I just wonder if the Deputy First Minister could just clarify the position with respect to, I know that the Deputy First Minister referred to that in her opening statements very briefly, but if you could just amplify the exact position, because I know that that had been the subject of some press coverage and controversy.
Well, I'm happy to do that. I don't have the evidence from Lord Wallace in front of me, but certainly the excerpt that Annabel Ewing read out there sounds, very similar to what I'm about to say to the committee. There has been some, very inaccurate reporting of this. I've seen reports suggesting that, servicemen or some servicemen will be barred from taking part in the referendum. Let me stress that the franchise for the referendum, with the exception of 16 and 17-year-olds, is the same as the franchise for Scottish Parliament and local government elections. So any serviceman or woman who is eligible to vote and on the register to vote for a Scottish Parliament or a local government election will be able to vote in the referendum if they're eligible and on the register. There are 3 ways in which somebody in the armed forces can register to vote. They can do it the same way as anybody else, as an ordinary voter. So they register in the same way as civilians by responding to the annual canvass or by rolling registration. If the address at which they are registered is in Scotland, then they will be eligible to vote in the referendum, and about 2/3 of those in the armed forces who are register through that ordinary process. Secondly, somebody in the armed forces can register as a service voter, and about 1/3 of those registered are registered in this way, and they do that by making a service declaration. Service declaration is valid for 5 years. They can register using a UK address, irrespective of where they might be posted in that 5-year period. So the declaration can either firstly register them at the address at which they or their spouse or civil partner are currently living, secondly where they would have been living if they were not in the armed forces, or thirdly, if they cannot say where they would be living if they were not in the armed forces, at the last address before they took up their post. Those registering in that way will be eligible to vote in the referendum if their service declaration is made using an address in Scotland. The third way that armed forces personnel can register to vote is as an overseas voter. Those doing that wouldn't be able to vote in the referendum because overseas voters are not able generally to vote in the referendum, but that accounts for about 1% of all armed forces personnel who are registered. So, just to summarise, if somebody in the armed forces is eligible to vote to elections for this Parliament, then they are eligible to vote in the referendum, and that is, with the exception of 16 and 17-year-olds, the same as for everybody else.
Thank you, Convener. And just to another related issue would be what kind of arrangements are in place to ensure that service personnel are aware of the options in terms of registration. Presumably there are arrangements already in place, and presumably they would continue operate with respect to this?
Absolutely.
vote?
I mean, you know, because we are here mirroring the situation that applies normally for elections, then, you know, obviously the processes that are used normally will apply. The Electoral Commission clearly, you know, will have to factor this into their own planning. They have the responsibility of awareness raising about the referendum and about registration and the rights to vote. So it will be part of the duties they have to ensure that that includes the particular situation of service personnel.
Thank you.
John, did you thought you might, it's covered, okay. Can we move on to the issue then of another issue you raised, First Minister, was prisoners. I think, Patrick, you wanted to raise that issue, and I'll come back to you on this, your participation. I think Tavish wanted to perhaps raise something there as well.
Thank you, Convener. Good morning. The Deputy First Minister's response to some of the evidence that we've had in writing on prisoners voting makes the case that there is not a legal obligation under ECHR to give prisoners the right to vote in a referendum, even if there's a question mark over the future blanket ban from participating in elections. Now, the Deputy First Minister might be right about the legal aspect, but I hope that there's some willingness to discuss at least the political choice which the government is free to make. Simply saying that there's not a legal requirement doesn't mean that this cannot happen. Does the Deputy First Minister acknowledge that there is at least an argument to be made that prisoners voting could be seen as part of a rehabilitation process, that there is a moral case in favour of it, and indeed that even if there's an argument for maintaining some degree of a ban on prisoners voting, that should be for courts to decide, rather than for a blanket mechanism that would allow courts to treat differently someone who's serving many years in prison for a very serious offence and someone who happens to be in prison for a few days or weeks as a result of a much more minor offence, but that happens to take place at the time of the referendum. Is there at least some willingness to debate these issues and acknowledge that there is a case for change?
Well, firstly, I mean, Patrick Harvey's not questioning the legal position put forward by the Scottish Government, and you know, I accept that, but it might be worth for the committee just to set that out. The ECHR is very clear in that what it has to say in terms of the right to vote is about the free expression of the opinion of people in the choice of a legislature. That and the case law that emanates from that particular provision, Article 3 of Protocol 1 of the European Convention on Human Rights, is very clear that that does not apply to referendums. I think the committee's had evidence from Professor Tierney, for example, that would back up that position. In terms of Patrick Harvey's other point, I mean, there's an argument to be made for almost anything, and I accept there's an argument that can be made, the argument that Patrick Harvey's just put forward. I don't agree with it, and the government doesn't agree with it, and the government is very, very clear that we don't think convicted prisoners who are serving a prison sentence should be able to vote in the referendum. But we are in a parliamentary process, and Patrick Harvey or any other member of the Parliament has absolutely the right to challenge that, to put forward an amendment and to have that debated. And you know, the government will put forward its position if that happens, and we'll have that debate. So yes, of course, there is an argument that can be put. There is a debate that will be had if that argument is put, and the government will state and justify its position in the normal parliamentary process.
Well, can I ask at this point, though, you say the government doesn't agree with this alternative case that can be made. Why not? Why does the government not agree that it should be for a court to decide, based on the circumstances of an individual offence, whether the deprivation of the right to vote is a part of the punishment for a particular offence?
But I don't believe, you know, we have it, and you said there's a question mark over whether this will continue to be the case for other elections, and that's something the UK government is considering. It's up to them what they choose to do, but right now it is the case that convicted prisoners serving a prison sentence don't get to vote, and I don't consider that there is a good argument for changing that for the referendum. People who don't commit crimes and don't get sent to jail for them will have the right to vote, and that to me is a pretty simple principle. I'm not saying it's beyond challenge. I'm not saying there's an alternative argument to be made, but that's my view. It's the government's view, and we'll debate that as we go through the parliamentary process.
I recognise the Deputy First Minister is simply saying it's the government's view. I'm asking why it's the government's view that this should be a matter for a blanket approach rather than a court decision. It's
reflecting the current position that if you commit a crime and the crime that you commit results in you being sent to jail, then one of the things that happens as a result of that is that you forfeit your right to vote. And I do not believe that a case has been made to make a change from that principle for the purposes of this referendum. And, you know, that's my simple view.
Stuart Maxwell had a specific point on a supplementary, and I'll come back to Tavish.
It's exactly on the court's point.
Issue.
Yes, it's exactly on the court's point. I mean, I've heard what Patrick says about we shouldn't have a blanket ban, it should be up to the courts to decide, but surely the position at the moment is that's exactly what happens. The courts do decide by effectively, after conviction, deciding on a custodial sentence. A court is deciding whether a person should lose that right or keep that right, because if they effectively gave a judgment which was a non-custodial sentence of some sort, then they are perfectly aware of the fact that that person would retain the right to vote. Isn't that the case, Deputy First Minister?
Absolutely. I mean, a judge right now passing a custodial sentence on somebody, and a judge in the run-up to the referendum passing a custodial sentence on somebody, if this bill remains as it is just now, will do so in the full knowledge that an implication of that is that that person doesn't get the chance to vote in the referendum. So it's one of the many things that people who sit in judgment of others will take into account in reaching their view of a sentence. But, you know, I repeat what I said earlier on to Patrick Harvey. You know, we are at the start of a parliamentary process. You know, it is entirely right and proper and appropriate for him or any other member of the chamber to put forward the alternative view. I readily accept there is a debate to be had. I'm not saying there are not arguments to be made on the other side. I'm simply stating as he is stating his view, I'm stating the view of the government, and Parliament will decide.
I think you wanted to come in this point as well.
Thank you, Convener. Can I just be clear, your objection to this is moral rather than legal?
My objection is just that we have a situation just now where people who commit crimes and get sent to jail don't get to vote, and I don't believe that a good case has been made for changing that. You know, if people want to vote in the referendum and want to make absolutely clear that they're not going to lose the right to vote by being sent to jail, then, well, there seems to me to be a pretty simple way of ensuring that that's the case. So, you know, it's not, I wouldn't really characterise it as moral or legal. I think the legal position is absolutely clear. I would just characterise it as a point of kind of practical, it's a practical view on my part, not anything else.
So removing the right to vote for convicted prisoners, you think is a punishment which should be added to their sentence?
Removing the right to vote, convicted prisoners in jail don't have the right to vote. I'm not removing anything.
You have the opportunity to give it to them.
And Tavish Scott, like Patrick Harvey, has the opportunity to argue the case of convicted prisoners.
But we're here to test your and the government's position, Deputy First Minister.
With the greatest respect, Tavish, if you let me answer, you will get the opportunity to test my view. What I'm saying is that you characterise what I was doing as removing a right. I'm correcting you to say I am not removing a right because the right doesn't exist at the moment. I'm simply clarifying in this bill that we don't intend to give convicted prisoners in jail a right that they don't currently have. And that's my view. I will defend and justify that view through the parliamentary process. And if Tavish Scott or Patrick Harvey or any other member thinks, as they are perfectly entitled to do, that that is the wrong view, then Parliament will have that debate and Parliament will decide.
I appreciate you've got lots of points to make on process. I'm interested in the government's position, not the process. So,
but I think I've made that pretty clear. I'm not sure what bit of it you don't understand.
Well, I'll ask the questions that I want to ask, if that's all right.
As well, on you go, Tavish.
Beg your pardon?
I'm just saying, make sure this discussion through the chair, so it's not just a barney across the floor here. So
not a barney.
On you go.
Well, I'm trying to ask some questions. I'm
sorry. Let me rephrase that. Just make sure we do this through the chair. On you go.
Thank you. In the circumstances that you've described in terms of the government's policy, would I be fair in assessing that you see no difference between someone who's serving a sentence under 6 months as opposed to someone who's serving a sentence in excess of 6 months?
The government's policy on this is if you commit a crime and a judge sees fit to send you to jail, then you should forfeit your right. Well, you don't have the right to vote in those circumstances just now, and that should continue to be the case. I'm not taking away in this bill, we are not taking away a right that any convicted prisoner has at the moment, and as Stuart Maxwell has rightly said, this is something that a judge would take account of, presumably, in reaching a decision on a sentence. So, the government's position is clear. I think the reasons for the government's position is clear. The process of challenging the government's position is clear, and I accept this is not necessarily a straightforward, simple issue for everyone, but we're in a parliamentary process where people have the right to put forward their own view, and if the arguments are good enough, then I dare say you'll be able to persuade MSPs to support the position.
Let me try again. Can I just ask if you see any merit in the argument about short-term sentences as opposed to longer-term sentences?
For the purpose, there's lots of arguments that draw a distinction between short sentences and long sentences, as the Scottish Government has made. But for the purposes of drawing distinctions in terms of the right to vote, we do not intend, and we do not think the argument has been made to give prisoners, whether they are sentenced for a short period of time or a long period of time, the right to vote, which is a right they currently do not have. So, no, if we thought there was a distinction to be made there in the context of voting in the referendum, then we would have made that distinction in this bill, and we haven't.
Can I also check, Convener, I'm sure the Deputy First Minister has read the evidence that's been provided by the Howard League for Penal Reform in respect of other countries, but she presumably is aware that Denmark, Finland, Ireland and Sweden, just to mention just a number of countries, have no form of electoral ban for imprisoned offenders. Do you just disagree with that position, I presume? Well,
I think it probably doesn't take much to work out that I do disagree with that position. If I didn't disagree with that position, I would have drafted a bill that we're currently discussing in a very different way. I'm trying to be as reasonable about this as possible. I'm respecting the view that others are putting forward. I respect the position other countries take. I respect the fact that there is a difference of opinion and an argument to be had. I'm simply putting forward my view and the view of the government. And, I don't really see what Tavish Scott is finding so difficult to understand. But I accept he doesn't agree with it, but I don't see what's very difficult to understand about it.
With respect, I didn't say I agreed or disagreed with it. I was just trying to test the government's position.
I'm just taking it from your mood music.
John Lamont wanted to be involved in this discussion as well.
Thank you, Convener. I agree with the government's position in terms of preventing prisoners from voting. You say that the legal position is clear. I just wonder if the government has taken legal advice about the possibility of a prisoner who is prevented from voting challenging the outcome of the referendum, and whether that is advice you might be able to make available to us.
I'm going to not rehearse all of the usual things about legal advice, etc. Let's just say we've taken account in coming to the position we've come to in this bill of all the legal considerations and arguments. I think the legal position is very clear, not just in terms of the wording of the particular clause in the European Convention, but the case law that has resulted from that has made clear over the period of time that those cases have been discussed that it does not apply to referenda, it applies to elections, to parliaments and legislatures.
Lastly, Section E of the bill excludes from voting a person detained by virtue of a conditional pardon. I wondered if the Deputy First Minister could tell me the last person in Scotland who was detained under such a conditional pardon.
No, I can't, but if the member can, I would be happy to hear it.
I think it might have been Oscar
Was
Slater.
it a Conservative MP by any chance? No.
Right, well, I think we'll move on to that situation. And I'll come back to you on participation issues, Patrick, but I think Rob wanted to raise issues and more generally about guidelines around debates, etc. in schools. Have I got that right, Rob?
Yes, indeed. We discussed, Convener, with the EROs and the Directors of Education and the Electoral Commission about the registration process and about participation in voting. And I'd like to ask the the Deputy First Minister if the materials which the government will produce for information about registration, if you are, or about the process or about the issues, will be made available for people to see at an early stage?
It will be the Electoral Commission that provides the material for raising awareness of the process of registration and the process of the referendum. So it would be for them to, discuss with you exactly what process they would go through. The government itself won't be producing that information.
Well, as they have said, presumably there will be material that the government will be producing about the referendum as such. And there was a discussion, convener, that we had about balanced material being available in schools on that subject. Obviously, there's the question of people with different points of view. But the government has a role in this, and I just wanted to tease out if the government has.
Well, the main publication that the government will produce, of course, is the White Paper, which will be the case for Scotland being independent, and we will, as the government, try to ensure that there is as wide an appreciation and knowledge and understanding of the White Paper as possible, and that includes with everybody who is entitled to vote in the referendum. Clearly, the other side of the campaign, those arguing against independence, will also want to make sure that the information they put forward is disseminated as widely as possible. The Electoral Commission, its information will not be giving details on the case for or against independence. It will be information about the process of the referendum. It will be for campaigners on either side of the debate to put forward their case, and certainly speaking for the government, and I'm not here to speak for the broader campaign of which I'm a part, but I'm sure it is the case for them that we will be doing our level best to make sure that information is accessible to all potential voters, including those in the younger age group.
It's on that particular point about the younger age group, and also in their native languages, that material should be made available. And I assume that when you've said that, convener, that the Deputy First Minister is agreeing that such materials from the government will be in a variety of languages and at a level which will be able to be understood by a range of 16, 17-year-olds.
We will certainly take great care to ensure that, whether it's in terms of language provision or the way in which we're presenting material, we're making it as accessible as possible to everybody who has the right to vote in the referendum.
You're a small supplementary on that.
Small supplementary, if I may, convener. If in answer to Mr Gibson, I think the Deputy First Minister said that the government would provide the White Paper to everyone eligible to vote, but please, if I've got that wrong.
I didn't say that. I said we would be working hard to make sure it was accessible to people. The form in which we will do that hasn't yet been decided, but I didn't say, and I think the record will show, I didn't say that we would.
Say you did. I'm just trying to clarify what you did say in respect of.
Hopefully I've done that.
And so, are there any details of how that White Paper will be made available, or is it just through the normal publication of government documents?
We will give consideration to. It certainly will be available through the normal processes of government publications being made available. We will, give consideration to whether there is more we can do to make that as accessible as possible, and Parliament will have the opportunity to know what we propose in due course. We've not made any final decisions about that.
I quite understand that, but the point I was asking, convener, is this is obviously a government publication as opposed to a campaign document from either side of the referendum debate. So could the Deputy First Minister clarify for me how that factors into that overall assessment the Electoral Commission will have to make about publications being made to people in respect of campaign material?
I don't think the Electoral Commission have that job of assessing whether the campaign on either side of the debate is balanced, or that people have adequate information. It's not part of the Electoral Commission's role. The Electoral Commission has said in its report on the question that they hoped both sides would manage to come together and, I'm paraphrasing now, give a sort of joint statement of the process that would lead to independence following either outcome, I think they said. But it's not the job of the Electoral Commission to assess the information that either side of the campaign puts forward.
That's very fair, I completely accept that, but this is a document that will be provided for by the government. This is a government white paper, and it is by definition a document which will make the case for independence with the full power and money behind it of the government in terms of that, of how it's sent out and how it's used. That be fair?
We have a responsibility to use taxpayers' money responsibly and appropriately, and that will apply to the white paper as it does to anything else the government publishes. So we will balance that with, I think, the the view there is on both sides of the debate that people need to be as informed as possible. I mean, there's not a day goes by just now when I don't get told by those on the other side of the debate that the government needs to provide more information and more answers on different questions. So we will certainly endeavour to do that.
Can we get back to the bill itself now? Patrick, I think you wanted to... sorry, can I just make sure Rob Gibson had no further question?
At this point, no. Thank you.
Patrick, I think you had issues about participation issues, and probably both on registration and turnout.
Well, registration and turnout, as you say, convener, hopefully a slightly more consensual area than my last line of questioning. I would like to hope that we all want to see a high level of participation by young voters, 16 and 17-year-olds and young voters in general, and the Deputy First Minister on a few occasions has talked about a desire to see all of them participate once they're registered. The committee's heard evidence from some smaller jurisdictions, Jersey, Guernsey, Isle of Man, that have already reduced their voting age to 16. I'm just wondering, not only in response to the evidence the committee's heard, but has the government looked at those or indeed other jurisdictions to try and figure out what works at driving up turnout, particularly of young voters, given the newness of the process to them, but also the opportunity to engage with them through educational institutions in a proactive way, in a way that's not possible with older voters?
I mean, yes, the short answer is yes. We've looked at other jurisdictions. We've also looked at the very limited experience there has been in Scotland of extending the franchise to 16 and 17-year-olds in the pilot health board election, Crofton Commission, etc. So, I'm not saying they tell us necessarily very much at all, but we have looked at all of that. It is the Electoral Commission's role, of course, to raise awareness of the registration process and the process of the referendum. So it will be core to what they are doing as part of that process to ensure that there is as wide an understanding and appreciation of the right of 16 and 17-year-olds to register as possible. Clearly, both sides of the campaign will have an obligation and an interest in getting young voters registered and keen to participate in the referendum, and I'm sure both sides of the campaign are already, I know at least on the part of one side of the campaign, they're already thinking very carefully about how to do that. I mean, I'm not complacent about these things at all. I don't think any of us with experience of elections could be complacent about turnout full stop for any age group. But my anecdotal experience of speaking to people about the referendum leads me to think that there will be a high turnout in the referendum and that it will span all age groups. Now, that shouldn't mean we take our foot off the pedal and don't work hard at it, but that's my strong impression based on the conversations I'm having just now.
I certainly hope that's true, and I guess I'd like to think we all hope that's true. The evidence we've had shows that there's some really good, innovative, creative work that's happened in some schools. But we all know, I think, as MSPs with a constituency or a regional responsibility, that there are other schools that don't particularly get involved in mock elections or any of these other kind of processes. Do you think there's room in the bill for a duty on local authorities, particularly in relation to the provision of education, that they have duties relating to the promotion of participation?
I'm certainly happy to give that consideration. But I would say at this stage that the Electoral Commission will have a statutory responsibility to raise awareness and understanding of the voter registration process. So in a sense that, and they, in order to fulfil that statutory obligation, will need to work with a range of different organisations, including local authorities, schools, to make sure that they are doing what is required of them. So.
Electoral activity, though, that some of this really good creative work happens in schools where head teachers choose to let them in. We'd like to see, surely, a consistent approach to promoting participation in all schools.
I agree with that, so I'm happy to give consideration to that proposal, and I'll come back to the committee in due course to tell them the outcome of that.
Thank you.
John, I think you wanted to...
My question relates to the participation and engagement of young people as well. I'm just conscious that many of them, or all of them, will still be at school doing studies and exams. I just wondered what the government's view is in terms of ensuring it's not too much of a distraction, in terms of ensuring that the balance is struck between allowing them to do... Yeah, well, indeed, to ensure that they're able to do their exams, do their work and not be distracted by this vote.
I mean, I kind of take the opposite view, that actually if young people are interested and engaged, then it's actually good for their development and probably good for their kind of, you know, how informed they are as citizens, which can only be good in terms of their educational experience and outcomes. So I kind of look at it maybe more from a sort of half-glass full perspective. You know, ultimately, and notwithstanding Patrick's point about consistency, you know, ultimately it is for a head teacher and an education authority to determine what happens in a school. And in my experience, and again, it's, you know, I accept Patrick's point that this is not a universal general statement, but in my experience in my own constituency, schools do this very, very well in terms of engaging young people. In some respects, I actually think primary schools do it right now maybe even better than secondary schools, which maybe is an issue that we have to think about. So I'm quite optimistic that the right foundations are there for this, to get that balance right and to make sure that young people are engaged. I think there will be a natural level of interest. I know there is at the moment, and we've got to make sure that the right steps are taken to capitalise on that, and that's why the role of the Electoral Commission will be so important.
Any other outstanding questions? I know Stuart McMillan wanted to go back to one other issue that was raised earlier, but on you go, Stuart.
Thank you, Convener. Deputy First Minister, I mean, you mentioned earlier on regarding the paper with the registration forms out for testing at the moment. And I've raised an issue in the past in committee regarding the colour of the paper. And I've raised the issue certainly for two particular reasons. One, to make it easier for when the form comes into a household, to make it easier for 15-year-olds to fill out the correct form. But secondly, for the issue regarding people who actually have a visual impairment, or people who might actually be dyslexic. So because the word accessibility has already been mentioned a number of times today. So in terms of going forward, will you certainly consider the issue of actually making the registration form a different colour to ensure that there is the widest possible accessible opportunity for 15-year-olds to register and to vote? I'm
happy to consider that. I mean, obviously, the testing of the form will give us a lot of pointers about whether and how we could improve it. But, you know, we're happy to listen to comments outside of that process as well. If there is a view that any particular aspect of the form could be improved upon, we will consider that, absolutely, including the colour of it, if that is something that's helpful to people with visual impairment.
Thank you. John Lamont.
Throughout this morning's discussion, I've been struck or just reminded about the important role of the Electoral Commission. I'm just wondering if the government is satisfied that they have sufficient funding to allow them to do the job which you expect them to do, or we all expect them to do.
Yes, and I believe, although I will be corrected if I'm wrong, I believe they have said in evidence that they're satisfied that the financial provisions we're making for them are adequate as well.
I think that's probably exhausted our question session. Just one final question from me, though, Convener, maybe, and Steve maybe needs to help here. It's just a technical thing. You've already confirmed there'll be one amendment coming forward to deal with Section 13 issues. Have you any idea of any other amendments at this stage you might want to tell us about or make us begin to think about?
I think there's a few kind of very technical things which I'm happy to give the committee, you know, advance notice of if in order to get your views if possible. There's nothing at this stage, although I've given agreements to consider certain things today, but there's nothing at this stage that is particularly substantive that we're planning.
In that case, can I thank the First Minister and our team for giving evidence on the franchise bill today. Very grateful. Thank you. We now go into private session.